Good morning again to those who've just joined. Just before we get going, be grateful if you could link in with David and I through the QR codes instructions on the front of the document. And if you'd prefer to link in with us via old-fashioned methods, phone number and email are at the back if you'd prefer that. So I'm Neil Burton. I head up the charity sector at Mills and Reeve, and I advise universities and large charities on a range of corporate matters, governance matters, but including setting up, running, and exiting trading subsidiaries. David Hollier is joining me. David is a principal associate, senior lawyer in our corporate team, advises universities on a wide range of corporate matters such as university mergers and again setting up, running, and exiting trading subsidiaries. In just a little bit of housekeeping, there'll be a recording of this available to you after the recording. Also, just a plug, there have been two previous sessions that are recorded and available. The first of which my colleagues Poppy and Helen gave on setting up trading subsidiaries, so do look at that. And then a second session by Steph Caird and James on IP issues arising out of your trading subsidiary, and this is the third and final session on exiting trading subsidiaries. If you've got any questions, please do pop them in the Q&A box, and hopefully we'll have some time at the end to answer some of those. And if you've got a burning question and we don't get to it, please do drop us an email and see if we can help. And lastly, really appreciate it if you could just take a few minutes to complete the feedback survey in terms of the usefulness of this topic, and indeed any other topics that you think it would be helpful for us to put on. So, trading subsidiaries. So we've got the kind of the exit session. So an outline of today, we're going to cover two buckets, two areas of exit. One is where they don't go so well, and we have to close them on a sort of insolvent or solvent basis. And just to provide some background for that, not as I'm sure you know, all businesses don't work out. The Experian stats from earlier this year actually say that in the first year of trading, 4% of businesses fail, 34% of businesses fail in the second year, and just under 50% fail within their third year. But that means, 50% are successful. So that's what we're going to focus on in our second session, which is profitably exiting trading subsidiaries. But they don't all work out. So we'll also start with how you exit a trading subsidiary that's not working out so well. There are a few themes that I thought I'd just start with, and David will return to these. And these are themes that we regularly see from our university and large charity clients in terms of questions that pop up relating to their trading subsidiaries. The first of which is going back to Poppy's first session, really do start with the end in mind with your trading subsidiary. Have a good think about the life of the trading subsidiary. Are you setting it up for a short project? How are you going to exit and close it? Or is it a long term? Do you intend to hold it? Do you intend to sell it? And most importantly, ensuring that you have appropriate funds available to close it down on a solvent basis. Always remember arm's length arrangements. So treat your trading subsidiary like you would a third-party investment in terms of time, people, resources that you give the trading subsidiary, the way that you govern it. Treat it like a third party. Think about we see that the university with their trading subsidiaries are very intertwined in terms of services, people, property that's made available as between the university and the trading subsidiary. So if they're going to separate out, how are you going to decouple them? And lastly, good governance is key, particularly with trading subsidiaries. So that's particularly relevant during the life of the trading subsidiary, but really important at point of exit. So monitoring and maintaining good governance, in particular managing conflicts of interest. So I'll now hand you over to David, who's going to get into the meat of it.
Good morning, everybody. As Neil mentioned earlier, for those of you who've had the opportunity to listen to the first webinar in this series, Setting Up and Managing Trading Subsidiaries, you will have heard my colleagues, Poppy and Helen, discuss that broadly speaking, there are two types which a university may look to set up. A subsidiary, the activities of which further the university's own charitable objectives, and thus may be an exempt linked charity. And the second camp, trading subsidiaries, the activities of which do not further the university's own charitable objectives, such as those set up for commercial gain, possibly with one or more commercial partners. We'll be focusing today's session on the latter. As Neil has mentioned, the first part of this talk will be about trading subsidiaries in financial difficulty, which may be suitable to be wound down. And the second part will be about the process involved in exiting all or part of a successful subsidiary. Okay, so as Neil's already mentioned, the commercial reality is many trading subsidiaries have a material prospect of not succeeding, at least not in the form initially envisaged when setting them up. Please do not look at this as us being unduly negative. Rather, we want to impress that this is simply a commercial reality of business. So with that in mind, what can be done to mitigate risk, and what should universities be mindful of when supporting trading subsidiaries? Where we say upfront planning is key, what we mean by this is start with the end in mind wherever possible. Points to think about from the outset include composition and management of directors. It is likely that most of a subsidiary's directors will be employees of or otherwise connected to the university, trustees, executive, etc. The Charity Commission guidance also recommends one or more independents can be appointed to the subsidiary board, who may, of course, bring different types of expertise and a different perspective. Managing conflicts of interest between the two will be an important aspect, and an appropriate legal framework dealing with this should be included from the outset. This can include safe harbours in a subsidiary's articles of association, whereby interested or conflicted directors, i.e. due to their relationship with the university parent, can nevertheless be authorised to vote in board resolutions of the subsidiary. Governance and the relationship between the university and its trading subsidiary. Now, the trustees of the university must ultimately exercise the university's rights as shareholder in the trading subsidiary so as to promote the university's interests. The directors of the trading subsidiary will be responsible for the day-to-day management of the subsidiary, but other major decisions should be reserved for the university. For example, the university should be responsible for the appointment and removal of directors from the subsidiary board, the directors' terms of service, including remuneration, and the continuation or dissolution of the trading subsidiary. Many of these university rights can be enshrined in the subsidiary's articles or other legal documents. Funding structure. As we will come to discuss further in a moment, as charities, universities cannot simply write blank checks in support of their trading subsidiaries. However, it is not uncommon for a trading subsidiary to receive some funding from its parent on its creation, often by way of a loan, but also sometimes as a result of the university buying share capital in its trading subsidiary. A practical point on funding structure would be, whilst the university should consider committing a realistic level of funding to its subsidiary on day one, this does not necessarily mean that all funds have to be released on day one. For example, funding can be released in tranches and can be made subject to the provision of information by the subsidiary, such as accounting or financial, and there can also be the inclusion of financial or other covenants contained in a formal loan agreement. Monitoring. It is, of course, important to have detailed financial and business plans drawn up where possible to help develop an informed understanding up front of the level of funding and other commitment and other help which may realistically be required by the subsidiary. This is prudent as it can become really difficult for a university to try and step in later down the line with financial support in situations where a subsidiary has already fallen into financial difficulty. Once an appropriate funding framework is in place, the university's financial position should be subject to ongoing and regular monitoring and review, which is the same, of course, as for the university's other investments. Where a trading subsidiary is not charitable, the university must consider an investment in the subsidiary in the same way as they would consider any other charitable investment. The subsidiary of the university cannot receive special treatment because of its operational links to the university, and agreements put in place between the two should be on an arm's length basis. University trustees must be mindful of their legal duties to act in the university's best interest only, and to make sure university assets are only used to support and carry out its charitable objectives. It is crucial, therefore, that a parent university's trustees are able to justify financial support for the trading subsidiary as a suitable way of investing the university's resources. As such, before making investment in a trading subsidiary, particularly one which looks like it could fall into financial difficulty, the university must consider the following at a properly constituted meeting and make sure its decisions are properly documented. Consider if the investment is suitable, having regard to the university's other investment options. Consider the trading subsidiary's business prospects and whether it can be satisfied of its financial viability and ability to repay any loans, which can be based on business plans, cash flow forecasts, etc. Whether it is appropriate to register a charge over the trading subsidiary's assets as security, and whether it could be appropriate to prepare a formal loan agreement, and if so, on what terms, including, for example, the current commercial interest rates appropriate for such a loan. Consider also preparing what we'd like to call a formal qualifying investment report by the university, which can be seen a bit like a business case regarding investment into a subsidiary, which the university would then be able to refer back to in the future. As to practical tips, if a level of funding has already been committed to the subsidiary and ring-fenced by the university for that use, this can make it easier for a university to justify that honouring such funding commitment does still constitute a reasonable investment decision down the road, potentially even where the subsidiary has fallen into a level of financial difficulty. Another point would be, it is typically less risky for a university to provide further funding by way of loan rather than buying share capital in the subsidiary. This is because a university should be more likely to receive repayment of a formal loan in the case of an insolvency situation, in particular if it has been secured on the assets of the subsidiary. In contrast, if a trading subsidiary becomes insolvent, shareholders will be the last to be repaid, if at all. Also, it is worthy of note, if providing funding to a subsidiary does not represent an improved charitable investment or expenditure by a university, it may have to pay corporation tax on the funding provided. Overall, it can, in certain cases, be a difficult balancing exercise, and if it appears on review that the trading subsidiary will make financial losses, the trustees of the university must act in a way to minimise loss to the university, as it is, of course, their duty to safeguard its assets. It is not appropriate to prop up an insolvent trading subsidiary with charitable funds, whether by loan or otherwise, as this could constitute a breach of the university trustees' charitable duties. So, if acting in accordance with their duties, the trustees of the university have not felt able to offer financial support or further financial support to a subsidiary, and it looks as though it may become insolvent, at that point, it may be appropriate to attempt an orderly, solvent winding down where possible. An orderly winding down may, for example, help to protect subsidiary directors, many of whom, as we have discussed, will likely be employees or otherwise connected to the university. Such employees may well understandably be reluctant to take part in future subsidiary or similar projects by the university if they do not feel as though they were looked after and supported by the university by having to deal with a messy insolvency situation, if it could have been avoided. Moreover, often the university itself will be the main creditor of the subsidiary, and an orderly winding down may help avoid a PR situation and ultimately mean the university writing off less of its loans and investments in the subsidiaries than may otherwise have been the case in a full-blown insolvency situation. As a further practical tip, it is important to ensure that directors of the subsidiary benefit from an appropriate level of D&O insurance cover. It is also worth noting here that on a winding down of the subsidiary, the legal and operational relationship between the two would need unravelling and terminating, which may include consideration of things such as service arrangements, back office support, use of university IP, and premises leases and licenses. In a worst-case scenario where an insolvency situation arises, the picture changes, including importantly in relation to the duties of the subsidiary directors, which shift from being owed to the university, a shareholder, to principally being owed instead to the university's creditors. In other words, in an insolvency situation, subsidiary directors are required to manage the subsidiary for the benefit of creditors so as to mitigate against the risk of wrongful trading and breach of other fiduciary duties on the part of such directors. In such a situation, the university may find itself in the position of having to write off a significant amount of its loans and investments made in the subsidiary. Things such as having security registered over the subsidiary and its assets to aim to rank higher in a creditor preference may be of some use, but ultimately, if the subsidiary has limited or no funds, it will not be possible for creditors to properly recover amounts owed to them. If a trading subsidiary looks like it has become insolvent or there is a material risk that it will do so, early advice from a professional insolvency advisor should be sought as a matter of urgency. Okay, so we're going to flip the script for the second part of this talk. So let's move on to talk about exit and sale of a successful subsidiary. For whatever reason, the time is right to sell, whether it be operational, opportunistic, or strategic. And we want to take a moment now to look at the high-level considerations when exiting. Things to consider will often include valuation. If a price has been offered by a potential buyer up front, how has it been calculated by the prospective buyer? Advice from accountants and or corporate finance advisors or similar is usually recommended at an early stage to make sure that the valuation has been tested and is realistic and fair. Will it be a sale of whole or of part? For example, if a sale of only part of a university shareholding, careful thought will need to be given as to the ongoing legal arrangements in place with the other shareholders, for example, investment shareholders agreements and articles, to make sure the university still benefits from an appropriate level of protections, possibly as a minority shareholder going forward. If a part sale of a subsidiary's business or assets, the parts being sold will need to be properly separated from that which is being retained. Something we see a lot of is concerns or issues or relative complexity around decoupling existing arrangements in place between the university and the subsidiary. There may be arrangements like this in place, which can vary from IP licenses, intragroup services arrangements, staff sharing arrangements, and more, which will often need to be decoupled, amended, or terminated as part of a sale or exit. As such, depending on the structure of the sale, a pre-completion reorganization may be required to hive up or down certain assets to or from the university. Consent to novation of material business and other contracts may be required, particularly on an asset sale. There may be bank or other funding consents required for the sale. Deeds of termination may be required in respect of certain contracts, IP licenses, grant funding arrangements, etc., to ensure the university is released from ongoing liability and obligations under such arrangements post-completion. And there may be employee issues to consider, including staff sharing arrangements, pension arrangements, and more. As a practical tip, even before an exit, if a university is considering into an arrangement, the benefit of which is principally for the subsidiary, careful thought should be given up front as to whether the subsidiary should enter into such agreement itself directly, or if not, whether sensible back-to-back and arm's length arrangements should be put in place between the university and the subsidiary to help protect the university. If a subsidiary is sold to a third-party buyer, the university will understandably want to avoid a situation where it could have ongoing liability or obligations in respect of arrangements that are for the benefit of a subsidiary which it no longer owns. Finally, the university may wish to preserve certain arrangements with the subsidiary following completion, such as access to services, data, IP, etc., albeit possibly on new terms negotiated with the buyer. In situations such as these, it is generally advisable to put this on the buyer's radar at an early stage so that any such post-completion services arrangements can be agreed during the sale process and be put in place simultaneously on completion of the sale. Will the exit be a share sale or an asset sale? There are some important differences between the two from a legal perspective, which is outside the scope of this talk. But from a mechanical perspective, if a share sale, the sale proceeds will be passed on to the university on completion. And if an asset sale, the subsidiary would remain in place, still owned by the university, and the sale proceeds would need to be passed up to the university by way of gift aid, subject, of course, to there being sufficient distributable profits to do so. Following this, it may be appropriate to wind up the subsidiary or for the university to repurpose it for a different use. Looking at planning for a sale, work we often encourage seller clients to perform upfront when contemplating a sale is a reasonable level of self-assessment, including due diligence. It's often surprising just how detailed a buyer's due diligence will be and the amount of time it takes. And one of the best ways to streamline this process is for the seller to try and front load some of this work itself. Generally speaking, due diligence can be separated into three core work streams: legal, financial and tax, and operational, and the use of virtual data rooms and diligence questionnaires to share due diligence materials with the buyer. has become commonplace given the high level of information which is typically exchanged. Typical categories of information to include in an initial due diligence questionnaire may include corporate structure and records, accounting and financial information, assets, insurance details, trading and contracts, including lists of key suppliers and customers and copies of the underlying contracts with each, litigation, schedule of any ongoing litigation in case there are disputes in play, anti-bribery policies and procedures, employee details, including terms, pro forma contracts, and details of any pension schemes, details of the subsidiary's property interests, including copies of any leases, licenses, or similar, environmental and health and safety, IP, including details of key registered and unregistered IP of a subsidiary, and details of any IP licenses granted to or from the subsidiary, IT, details of computer hardware, software, and any websites, including domain names, data protection policies, and registration with ICO if required. And finally, consents, details of any consents, licenses, or accreditations or similar required to operate the subsidiary's business. As a practical tip, when exchanging due diligence information, it is important for a seller to be mindful of its obligations under data protection laws, including redacting and anonymizing personal data before sharing such information with a buyer. Now, also, we've discussed what's on a due diligence questionnaire, but why is it that the buyer does so much due diligence typically on exits and sales these days? Well, one of the main reasons is for the buyer to try and identify whether there are any issues which may constitute a red flag and thus mean the target could potentially be worth less than the buyer initially thought. Some examples of potential issues we have seen come to light during diligence exercises include missing paperwork or defective share transfers or buybacks, disputes or litigation, particularly those which may not be covered by insurance, identifying regulatory or other consents which may be required as a precondition to sale, and missing or incomplete statutory books. Under the Companies Act 2006, a company's statutory books, which are of course separate to the information typically required to be filed at Companies House, constitute the definitive record of share ownership, and accordingly, a well-advised buyer will not complete a sale without having seen the books to check they exist and that their contents are in order. If these or any other issues are identified during due diligence, the seller should discuss them with their legal and other advisors at an early stage, and depending on the issue in question, it may be appropriate to involve the buyer, as they may have a particular preference on dealing with the issue. Finally, it is important to note that what will the governance at university and subsidiary level look like to determine who will negotiate the sale and be responsible for signing off the transaction at an early stage, and an appropriate level of delegated authority should be issued accordingly. Okay, so the seller has carried out a reasonable level of due diligence and other self-assessment work pre-sale, and a preferred buyer has been chosen. So what do then the main stages of the share process typically look like from a legal perspective? I won't go through all 7 of the headings listed here in great detail, but to pick out a few. Heads of terms can be a very important document and should be drawn up prior to the drafting of long-form documents to record the key commercial terms agreed by the parties, such as price, payment profile, any period of exclusivity, any conditions for the sale, and any other issues which the parties have identified in their upfront commercial negotiations. This can be a really useful document to refer back to if, for example, negotiations become protracted, to remind the parties of the commercial terms and the intention which was initially agreed. It is also important that confidentiality arrangements are put in place with a prospective buyer using an NDA or similar, given that sensitive information will likely be exchanged. Moving on to look quickly at share purchase agreement or asset purchase agreement. While this will be the core document, the sale and drafting, the negotiation and drafting of which will be a large part of the legal work required. This document will include the key terms of sale, consideration, completion, conditions and deliverables, warranties, and other things such as post-completion obligations or restrictions which may apply to the parties. Also, if any regulatory or other consents need to be obtained before the sale can complete, the sale agreement can be prepared so as to provide for a conditional sale with a split exchange and completion, rather than simultaneous exchange and completion. There will also be a disclosure process, as a share or asset sale agreement will typically contain a suite of warranties, which the seller will be able to disclose against prior to completion. There will be ancillary documents, which include things such as the corporate authorizations required by both buyer and seller to enter into the agreement. Project management will be a key factor throughout, and it will be necessary for the seller to have regular calls and other exchanges with its advisors, including to discuss negotiations on the terms of the sale documentation and working alongside its advisors to complete the due diligence and disclosure processes. And then finally, once the documents are in agreed form and have been signed, a time for completion will be agreed and then usually confirmed on a call between the parties' lawyers. Following completion, if monetary consideration is being passed, the sale proceeds will then be transferred electronically to the seller directly or to its lawyers for onward payment to the seller. I hope you enjoyed this part of the talk. I will now hand back over to Neil to commence the Q&A.
Thank you, David. So just looking through the questions that have come in. So the first one I'm going to tackle is, can a university guarantee the activities of a trading subsidiary, e.g. to a bank? Can it do that? So can a university guarantee to a bank a loan that's made to a trading subsidiary? Well, the answer, typical lawyer answer, the answer is yes and no. If the answer is no, if the trading subsidiary is undertaking commercial activities, so something that the university can't do itself. In those situations, the university cannot guarantee that loan. What can it do? Well, as David said, it could potentially provide a loan itself rather than going to the bank. It could put some share capital in. So there are alternatives. However, if the trading subsidiary is doing something that the university could do itself, so the university's decided to put certain education activities into a subsidiary, then there is potential that it could support it and potentially guarantee a loan because it's doing something that the university could do itself. So in those situations, potentially it can guarantee and there would be no breach of trust. The second question, David, we're sort of getting short on time, but just cover one other question. There's a question coming, what sort of regulatory consent? You mentioned regulatory and consents could be required on a sale of a trading subsidiary. Could you give some examples that they've asked?
Yes, thank you. So obviously it depends on the business activities of the subsidiary. But depending on what it does, there could be regulatory or other consents required by law before a sale can complete. Some examples we've seen before could be, for example, the relatively new piece of legislation called the National Security Investment Act. So if one of the sensitive areas are engaged, which are things such as defense, AI, synthetic biology, to name a few, then it could be that you need to make an application and get clearance from the relevant government body before you can complete your transaction. A few other examples we've seen where the subsidiary is carrying out educational activities could be consent for the Department of Education or other accreditory bodies. And then a more common one could be funder consent, depending on the banking arrangements of the university or subsidiary and whether, for example, banking arrangements are coming to an end if there's third-party funding involved, and whether you might, for example, need a deed of release in respect of existing security. If it's identified that a consent is a requirement prior to completion, as I touched on earlier, you can actually change the structure of the sale document slightly. So it can be a split exchange and completion conditional upon that consent being received, rather than there just being a straight signing and completion all at the same time.
Thanks, David. We're up on time, but there's a good question that's come in, so I'm just going to tackle that, and then we'll call it to an end. So the question is, what level amount of decision making should the university governing board be involved in? How much should be delegated? So that's a really good question, and that crops up fairly regularly. So I suppose the starting position is that the university, sorry, the trading subsidiary board, the board has the director's duties to operate the trading subsidiary, and they are responsible and have the fiduciary duties at the board level. So, what extent should the university board dip into the activities of the trading subsidiary? Well, there are certain things that will have to be approved, really key decisions that at law have to be approved when acting as a shareholder. So things like changes to articles, deciding to wind up, deciding to transfer and allot new shares, new funding. So usually those sorts of, well, those decisions have to go up to the shareholder, which is the university. So some universities, it goes to the full board. Some universities where, bigger universities with a number of trading subsidiaries, it goes to a sort of finance committee, which is fine. So rather than going to the full board, it goes to a delegated committee. So that's quite a neat way to do it. But what we quite often find with the bigger trading subsidiaries, the universities will want to keep um, more oversight of those trading subsidiaries, in addition to those sort of things as a legal default that have to be decided by the university. So quite often what we suggest to put in place is a kind of a reserve list of business. So let's say that the trading subsidiary wants to expand, it wants to borrow some money, it wants to sell off part of its business. As a matter of law, they are decisions for the trading subsidiary board. So what we quite often advise to put in place is it's the decision of the board, but they also need to escalate it up to the university, either the full board or quite often the finance committee, to get their approval as well. So it's really a balance and proportionality of the kind of the scale and size of the trading subsidiary and the decision being made. But do put something in place as between the two boards so that appropriate levels of delegation can be put in place. Thank you very much. We've just gone over time, I think, so I think we're going to close it there. So thank you, and please do remember on the to put in on the feedback, please.
Thank you, everybody.